you ever get involved in a legal dispute, you do not have to go to court. Instead, you can take part in ADR arbitration. Arbitration is an out-of-court resolution for any type of civil disagreement. ADR stands for Alternative Dispute Resolution. And arbitration is the most popular form of ADR. Oftentimes, disputing parties must arbitrate based on terms within a contract or agreement. A contract or agreement can feature clauses and provisions that enforce parties to avoid courtroom litigation and settle their differences through private arbitral hearings. At the conclusion of the hearings, an important third party known as an arbitrator will provide an out-of-court binding resolution. Sometimes, instead of one arbitrator, a panel or tribunal of arbitrators will preside over the hearings. Arbitration is the preferred process of resolving legal conflicts for countless individuals and companies across the United States. Why? Because parties can avoid expenses and delays within a much more relaxed and informal atmosphere compared to courtroom litigation. Say that two parties decide to submit a dispute toward arbitration. The parties must agree to adhere to an arbitrator's upcoming decision. That decision refers to the official arbitration award. The award will be provided once both sides present evidence and bring in witnesses to testify. Think of an arbitration award as a new contract between the two parties. This means that every award has legal binding status. A courtroom will almost always confirm an arbitration award, and it is very rare for an award to be vacated. Once an award gets confirmed by the arbitrator, the relevant court will officially designate the terms as an official binding judgment. Arbitration and alternative dispute resolution hold many advantages over standard courtroom litigation. First, it is encouraged for arbitrating parties to work together in a peaceful manner. This way, the chances increase that a binding resolution can be structured in a manner that is beneficial for all parties. Also, arbitration is less formal and more flexible than standard courtroom litigation processes. This leads to most disputing parties saving both money and time. Unlike courtroom trials, parties have the freedom to schedule hearings when they please. They do not have to adhere to the rigid structure of U.S. court proceedings. Compared to standard court trials, ADR and arbitration feature simplified rules of procedure and evidence. After all, many people complain about how complicated the rules of evidence are in litigation. But the majority of these rules do not apply in ADR and arbitration. One key reason is that the right to discovery is limited through ADR processes. The discovery process is what allows the parties to obtain facts and information from other parties in order to support a case and prepare for hearings. In fact, many arbitration agreements limit the right to discovery on their own, or the arbitrator will go out of his way or her way to reduce the impact of discovery. ADR and arbitration also features limited grounds for judicial review. This way, each arbitration award can maintain complete binding status. Thus, parties do not have to risk dealing with a lawsuit after arbitration concludes. Instead, they can move on with their lives. Also, the arbitration and ADR process is confidential and private. Unlike courtroom litigation, the information revealed in arbitral hearings does not become public. As you can see, there are many advantages to ADR and arbitration have over litigating in a courtroom. To learn more about arbitration and other forms of ADR, such as mediation, negotiation, and collaborative law, please visit arbitrationagreements.org. Our association is #1 in the nation when it comes to helping parties discover alternative solutions to courtroom litigation. You are also welcome to give our ADR experts a phone call at any time. Our number is 844-554-0444. We look forward to helping you discover the most ideal, cost-effective dispute resolution tools and resources.